effective August 16, 2004. Let me just read to you, in lifetime. Unless and until the Supreme Court directs otherwise, the lifetime or duration of the effectivity of any bond issued in criminal and civil actions, special proceedings, or in any proceeding or incident therein shall be from its approval by the court until the action or proceeding is finally decided, resolved, or terminated. So that is not the lifetime of the bond. Until the case is finally decided, resolved, or terminated. So it could go up all the way up to the Supreme Court until final resolution. That is the undertaking now, which should be, by virtue of the circular, which should be incorporated in the bond itself. That undertaking would be incorporated in the bond itself. Okay, now we're into the rights of the accused. Most of these rights, I know you have already discussed in your consti, because it was rights of the accused. For example, let me just point out to you, itong right to be presumed innocent, okay, this is basic. Right to be informed of the charge, the nature and cause of the accusation against him. What is required for purposes of this particular right? The right to be informed of the nature and cause of the accusation against him. The information itself, every formal indictment, every information that is filed in court must contain all the essential ingredients of the crime charge. Hindi naman enumerate mo yung essential ingredients. It must contain the facts. All the essential, the information, every indictment must contain the facts, or must allege facts, which are constitutive of each and every essential element of the crime charge. Because if the information does not contain or does not allege facts which are constitutive of the essential elements of the offense charge, that information, you know very well, is vulnerable to a quashal. On the ground that the facts charged do not constitute an offense. Because at the very moment the information is filed, the accused will also already have to be informed. How is he informed? Through the formal indictment, which must allege facts constitutive of all the essential elements of the crime charged. Now, that could be a ground for the quashal of the information. Okay. Second, the right to be present. Here, the right to be present in person, defend in person by counsel at every stage of the proceedings. Defend, to be present and to defend himself by counsel. First in person and by counsel. From what stage to what stage? From arraignment to promulgation. He has the right to be present. From arraignment to promulgation. Now, during the proceedings, can he be excluded? No, he cannot be excluded from the proceedings, because he has the right to be present in all stages of the proceedings. From arraignment to the promulgation. What about the private defendant party? What about the complaining witness? Can he be excluded from the proceedings? Can he be excluded? Yes, he can be excluded. Because he's only a witness in a criminal case. Although he may be the private defendant party. Because what is actually feared here is for them to jibe in their allegations with the witnesses as against the accused. But the accused can assert his right to be present in all stages of the proceedings, from the arraignment to the promulgation of judgment. Now, if the accused has this right, can he waive this right to be present? Yes. How is he going to waive his right to be present? One of the stipulations in the bond. He can waive his right to be present. He can waive his right, and that is a condition. And if there is a hearing, if he has to appear, waive the presence niya, the proceedings can proceed as against him. That is one of the conditions of the bond. Now, however, he cannot waive his presence if he is specifically required by the court to appear on this particular day. I cannot say, waiver naman ako. No. If the court requires you to appear on this particular day, for example, for purposes of identification, if a witness needs to identify the accused, or even private offending party himself or herself needs to identify the accused, then he can be required to be present. He cannot simply claim that, we name ko na eh. It is part of the conditions of the bond. No. So, while you may have the right, you can waive it, but you cannot waive it if you are specifically directed by the court to appear on that particular day. Okay, now, take note, the right to counsel. The accused has the right to counsel. The accused has the right to be assisted by a counsel to ensure that he is not denied due process. It must be a reasonably effective assistance by counsel. Hindi yung kukupo lang yung counsel beside the accused and let him do the talking. No, it must be a reasonably effective assistance by a lawyer, because that is his right to be assisted by counsel. What if in the entire proceedings the accused is assisted by somebody who turns out to be a fake lawyer? They found out that he's not even a member of the bar, but he has been represented. Di ba there's a recent case, in Marikina, the person is waiting for the result of the bar. He already practiced. He's now in jail. 2006 pa eh. So he's already practicing, and they found out he just took the bar. I do not know what happened to that case, but the point is, if you are represented by somebody who's not a lawyer, you're represented by somebody, you're the accused, you're represented by somebody who's not a lawyer, you're the accused and you're represented by somebody who is a fake lawyer, that amounts to a deprivation of your right. That amounts to a denial of due process on the part of the accused. Why? Because he is not represented actually by a lawyer. It is a fake lawyer, so void of representation. All proceedings will be rendered void. Because that would amount to a denial of his right to due process. So the right to counsel is right to reasonable, effective and reasonable assistance by a true lawyer who is a member of the bar. Okay, now sa right, ito very important. The right to be exempt from being compelled to bear witness against himself. This is of course the right against self-incrimination. I think you put this up in your evidence. Yung review nyo sa evidence coming pa, no? It's just verified. Very, very good. The right to be not to be compelled, the right not to be compelled to bear witness against himself, that is a right against self-incrimination. You take this up in your evidence. But the point is, this particular right is the right against testimonial compulsion. Take note, yung right against testimonial compulsion, that is the right against self-incrimination. Because it is not easily invoked in any circumstance. For example, yung mga decided cases na yan, in fact, there's with respect to the DNA. In DNA analysis, you will be subjected to DNA, for example, paternity suit. You will be subjected to DNA examination. You cannot object on the ground that your rights against self-incrimination will be violated. Because what does the Supreme Court say in these particular cases? The right against self-incrimination is a right against testimonial compulsion. Ito, something will simply be extracted from you. Remember the case of Villator versus Summers? Yung sa old case, the doctrine has not been abandoned. Yung Villator versus Summers in your consti, it's a prosecution for adultery. And remember, the woman was asked, kasi adultery. You know naman what adultery is, no? So, the woman is being charged with adultery. Okay, she was ordered by the court to submit herself to physical examination to find out if there is any foreign object in her body for purposes of the prosecution. She refused to submit herself to physical examination, invoking a right against self-incrimination. That will incriminate me if I submit myself to physical examination. What did the court say in that particular case? The court said, no! That will not violate your right against self-incrimination. Why? Because the right against self-incrimination is the right against testimonial compulsion. It does not involve the use of intelligence. You're simply subjected to physical examination. Lie down, spread open your legs, and submit yourself to examination. Does it require the use of intelligence? No way. Diba? Okay, so that is not, so it's right against self-incrimination. You take this up more in what is this? It's a 2005 case. What I said, Rosendo Alba, it's a paternity suit actually. Now, it's the man was being ordered by the court to submit himself to DNA because the woman's claims that the child was sired by this particular fellow. And then to settle everything, let us have a DNA testing. He refused. Because that would be violating of his right against self-incrimination. But the court denied and ordered him. He refused. He went up to the CA. The CA affirmed the order of the RTC. When he went up again to the Supreme Court, and the Supreme Court said, no, that is not violative of your right against self-incrimination. Remember yung while we're at it, no? Remember in the case of Betlan versus Samson? Yung writing, he was asked to take down dictation, and he refused. Sabi niya that would violate his right against self-incrimination. The Supreme Court sustained. Why? Because sabi ng Supreme Court, writing is not a purely mechanical act. It requires that it involves the use of intelligence. So that could be in effect a violation of your right against testimonial compulsion. It involves the use of intelligence. Okay, now, very important, the right to speedy, impartial, and public trial. Right to speedy trial. Take note, diba meron ng Speedy Trial Act, 1998. Okay, the right to speedy trial, and the speedy trial, the Supreme Court has said, in explanation of this, it involves a balancing of factors. The right to determination of whether or not there is a violation of someone's right to speedy trial involves a balancing of factors. What do we mean? The length of delay in the prosecution of the case may be considered as a factor. The length of delay in the prosecution of the case may be considered as a factor. But the length of delay, while it may be considered as a factor, nevertheless, you would have to consider if the delay was whimsically, capriciously made. If there are valid reasons for the delay in the prosecution that would not amount, that is attributed to the prosecution, that will not amount to a violation of the accused's right to speedy trial. You know very well, no? Under in the trial provisions, which incorporate the provisions of the Speedy Trial Act, there is now a limit. The trial would have to be completed in what do you call this? 180 days. Okay, so you have to move within that period. Would have to be completed. But there are allowable exclusions from the time limit that is provided under the rules. That is allowed under the rules. There are allowable exclusions. For example, if you read the rules, yung allowable exclusion, the delay caused by certain, let's say, certain other proceedings against the accused. For example, he got a TRO, or he's being held on other charges, where there is first a need to resolve this particular case before the case is resolved before this particular court. Or the delay entailed in locating a material witness. That is an allowable exclusion. So it entails a balancing of factors as far as delay in the prosecution of a particular case is concerned. Not every delay will amount to violation of the accused's right to speedy trial. It must be a delay without any reason. It must be a delay that is whimsical and capricious. Okay, now please take note. If a case is dismissed on the ground of violation of accused's right to speedy trial, that dismissal, please take note, is tantamount to an acquittal. That is by express declaration to the Supreme Court in a long line of cases. If the dismissal of a case is on the ground of violation of accused's right to speedy trial, that dismissal is tantamount to an acquittal. Ergo, tato, DJ. He can no longer be subsequently prosecuted for the same offense. Okay, we will get to that later when we go to trial proper. Okay. The right to appeals in all cases allowed and in the manner prescribed by law. As far as arraignment is concerned, you know very well, no? Arraignment, it is the time when the information is read to the accused in a language known to and understood by him. And he is now asked, what is his plea? How do you plead? It is how do you plead, not how do you feel. It is how do you plead, guilty or not guilty. That is the point in time. So he is informed First, he is informed via the information. That is his right to be informed. Second, he is informed again at the time of the arraignment of the nature and cause of the accusation against him, in the language known to and understood by him. After which, he is asked, how do you plead? Guilty or not guilty? If the accused, under the rules, if the accused interposes a guilty plea, but professes extenuating circumstances, that is, or he interposes a plea of guilty, but he raises certain circumstances that would extricate him from criminal liability, or if he would plead guilty but on certain conditions, those are in effect plea of not guilty. If he refuses to enter a plea, the court can enter a plea of not guilty for him. That's under the rules. Now, anong nabago? Please take note of, usually, the plea bargaining. If you notice, yung plea bargaining is part of the rule on pre-trial conference. That is the first step in a pre-trial conference in criminal cases. Plea bargaining. Because in your CIPRO, di ba the first purpose is explore the possibility of an amicable settlement of the case? You do not go on record as settling a criminal case because criminal cases basically cannot be compromised, correct? So ang first portion ng pre-trial conference nyo is plea bargaining. But plea bargaining, take note, sa totoong buhay, it does not happen only at the time of the pre-trial conference. Plea bargaining where there's already yung parang palengke. Okay, I offer to plead guilty, but you remit this particular plea bargaining. I offer to plead guilty to the lesser offense. Yung mga offers of aimed at plea bargaining, this can be done even before arraignment. Even before arraignment, mag-haggle for a better term for the accused. That is why, please take note, nowadays, what is scheduled is arraignment and pre-trial conference, all at the same time. Because there will be a possibility that at the time of the arraignment, the accused already will offer to plea bargain. Even at the time of the arraignment, the accused may offer to, for example, a very common plea bargaining, a very common form of plea bargaining is pleading guilty to the lesser offense. That is a very common. I plead guilty. Another form. Maraming forms yan eh. For as long as he can get a better deal. For as long as he can get a better deal, that is allowed under the law. Plead guilty to the lesser offense. Another form. For example, the accused is charged with several offenses. Several counts of one offense. Let's say, five counts of one offense. He offers to plead guilty to 2. I-remit niyo yung 3. That is a form of plea bargaining. Because if he remits the prosecution 3, he will only be penalized for 2, to which he is pleading guilty. That is a form of plea bargaining. Okay, so, if at the time, and remember, for example, if the offer to plead guilty, if the plea bargaining is in the form of offering to plead guilty to the lesser offense, under the rules, it must be, for it to be valid, for it to be effective, pleading guilty to the lesser offense, it must be with the consent of not only the public prosecutor, but also the private offending party. For it to be effective, the offer of the accused to plead guilty to the lesser offense, to be effective, must be with the consent of the public prosecutor and the private offending party. That is why, I'm telling you, kailangan nga, even during arraignment, and for pre-trial conference purposes, the private offending party is now notified. Because it may happen that the accused may offer to plead guilty to the lesser offense. So, kailangan dyan siya to give his consent. Now, under the rules, if the private offending party, if the accused offers to plead guilty to the lesser offense, this private offending party who has been notified but does not appear on the scheduled date, because there's some private offending party who say, arraignment lang naman yan eh. There's no need for my presence because you will simply be asked whether or not he pleads guilty or not guilty. So, I will want to plead guilty? No. Precisely, you are being notified in order for you to be ready if the accused offers to plead guilty or makes a plea bargaining. Paano nyo? So, under the rules, there is now a need for the private offending party to be notified, even for arraignment purposes, because the accused at that point in time may offer to plead guilty to the lesser offense. Now, if on the scheduled date of the arraignment, the accused offered to plead guilty to the lesser offense, and the private defendant party is notified but fails to appear, he is considered to have waived his right to interpose any objection to the offer of the accused to plead guilty to the lesser offense. Who alone now can give consent to the plea bargaining? The public prosecutor. Binibigyan lang siya ng chance to register his objection or to give his consent. Okay. So he has to, it is there, the private defense party would have to be notified. Okay, now, the private defense party shall be required to appear at the arraignment, see, for purposes of plea bargaining. Okay, so that is why now in court we set it for arraignment and pre-trial conference. That is for that purpose. Now, plea of guilty to a lesser offense. Take note of this. Remember, this already incorporates the provisions of the Speedy Trial Act. Before the revision of the rules in December of 2000, before the promulgation of the Speedy Trial Act of 1998, di ba may provision under the rules? The accused can offer to plead guilty to a lesser offense which is not necessarily included in the offense charge. You know, you read that, no? Before the revision, before the rules were revised in December of 2000. The accused can offer to plead guilty to a lesser offense which is not necessarily included in the offense charge. Which means that, if before the revision of the rule, the accused offers, accused who is charged with murder, for example, can he offer to plead guilty to jaywalking? Before the revision of the rules, kasi sinasabi, he may offer to plead guilty to the lesser offense which is not necessarily included in the offense charge. You know, when I read that provision, talaga pwede. He may offer, yes, but na-plug nila yung loophole. It will not be effective without consent of the public prosecutor as well as the private defendant party. Who in his right mind would agree to that? So now, to settle everything under the Speedy Trial Act, if the accused offers to plead guilty, and he will be allowed to plead guilty to the lesser offense, but that lesser offense to which he is offering to plead guilty to must be necessarily included in the offense charge. Remember in your criminal law 1, you learned this as a mitigating circumstance, plea of guilty, as an ordinary mitigating circumstance, for that to be considered, the plea of guilty, for example, to the lesser offense. That you will, after you're allowed to plead guilty to the lesser offense, hindi mo na pwedeng i-invoke yung plea of guilty as an ordinary mitigating circumstance. You take it up, no? You took this up in your criminal law 1. Okay. Now, as far as plea of guilty to a capital offense is concerned, please, a hearing is mandatory. Plea of guilty to a capital offense, a hearing is mandatory. Why? A hearing is mandatory because the court, remember, capital offense yan. So, penalized with death, although wala ng death na yan. Life imprisonment, reclusion perpetua. Okay, so, a plea of guilty, kailangan hearing. Why? Because the court would have to be convinced of the voluntariness of the plea of guilty. He has to be aware, the court would have to determine if the accused understands his plea of guilty. The court would have to determine whether or not he is aware of the consequences of his plea of guilty. And whether or not the plea of guilty is voluntary on his part. So a plea of guilty to a capital offense must always be set for hearing. Now, what about a plea of guilty to a non-capital offense? A hearing is discretionary. Why? Because the purpose of a hearing, if the accused offers to plead guilty to a non-capital offense, the hearing is only for purposes of determining the imposable penalty. But if it is a plea of guilty to the capital offense, kailangan yan may hearing. For the court to determine the voluntariness of the plea of guilty. Okay. Now, please take note. Bill of particulars. Take note, di ba yung bill of particulars, you find that in your Civ Pro. What is a bill of particulars? A bill of particulars is huwag niyo kalimutan, a more definite statement. Di ba? A more definite statement. That is the concept of a bill of particulars. This is likewise available in criminal procedure. Before arraignment, the accused may move for a bill of particulars to enable him properly to plead and prepare for trial. What is it that's being charged against me? Okay? So what is it that's being charged? I want specifics. So he may file a motion for bill of particulars. Take note of the next provision: production and inspection of material evidence in the possession of the prosecution. What is this? In your Civ Pro. This is the mode, very good, mode of discovery. So your mode of discovery, available likewise in criminal cases. This particular mode of discovery. Because we will learn later, many more modes of discovery available in civil procedure which are not available in criminal procedure. In criminal cases. So, production and inspection of material evidence in possession of the prosecution is a mode of discovery that may be availed of by the accused in criminal cases. Section 11 is suspension of the arraignment. I think I mentioned this last night. Suspension of the arraignment, dalawa dati, prejudicial question. Suspension, prejudicial question, because we said that there must be, the rule is, preference, tandaan lang ito preference in the prosecution of a criminal action over the prosecution of a civil action flowing from the crime subject of the criminal action. Do not forget the nexus, the connection. Kailangan establish niyo yung connection. The civil action must flow from the crime subject of the criminal action under Rule 111. This likewise applies in the rule on preference in the prosecution of a criminal action over the prosecution of a civil action flowing from the crime subject of the criminal action. Okay, so one suspension is an exception, must suspend ang criminal action, baliktad, in view of a prejudicial question or if the accused appears to be of unsound mind, suffering from unsound mind. Ito yung dalawa, ito yung third ground now, which is a new provision, suspension of the arraignment and other proceedings on the ground of a dependency of a petition for review filed either before the DOJ or before the OP, the Office of the President. But take note, there is a qualification. If the suspension of the arraignment and other proceedings is on the ground of dependency or the filing of a petition for review before the DOJ or before the Office of the President, that suspension should not be more than 60 days. Record from when? From the time of the filing of the petition for review. But most often than not, binibigyan pa yan ng extension. Anyway, this procedure, they can always invoke that the DOJ is not a set result, but we cannot be controlled by the DOJ. Remember I told you in Crespo versus Mogul, for as long as the information has been filed in court, and yan. For as long as the information has already been filed in court, the court is already the one to call the shots with respect to any disposition in relation to the case. Crespo versus Mogul. That is the prevailing doctrine. Okay, now, when you go to a motion to quash, there are old provisions actually in the motion to quash. No? First, when do you file a motion to quash? You file it at any time before arraignment. If you fail to file a motion to quash seasonably, that is, before arraignment, then your objections or your grounds for a motion to quash would be considered as waived. Correct? Except apat. Except apat. I think I mentioned this last night. No? You have to file a motion to quash seasonably. Seasonably before arraignment. If you fail to move to quash the information, you don't quash the case, you quash the information. If you fail to quash the information seasonably, your objections or your grounds waive. Exempt apat. Namely, 1. Lack of jurisdiction over the offense charge. No offense charge, meaning the facts charged in the information do not constitute an offense. Number 3, extinction of criminal liability. And number 4, DJ. Double jeopardy. Remember yung sa omnibus motion rule nyo, your SIPRO? Motion to dismiss under Rule 16. Motion to dismiss under Rule 16. Omnibus motion, all objections, all defenses must be pleaded in a motion to dismiss, otherwise waive. Except, di ba? Lack of jurisdiction over the subject matter, litispendensya, residicata, and prescription or statute of limitation. Disagree mo dyan sa criminal cases. You're talking about quassion of the information. In effect, dismissal of the case. Because once you quash information, the case is dismissed. So, you have to plead seasonably your grounds via a motion to quash the information, otherwise waive. Except, no offense charge, lack of jurisdiction over the offense charge, criminal liability is extinguished, and fourth, DJ, double jeopardy. Meaning that, under any of these exceptions, you can still raise them even after arraignment. Okay, isa pa. Please take note of the ground, no? Yung motion to quash, no need, facts charge not constitute offense. Now, please, basically, if your ground is that the facts charged do not constitute an offense, the Supreme Court has said that for the court to determine whether or not this is a valid ground for a motion to quash, the court does not go beyond the four corners of the information. And evidence allumed will not be accepted or outside of the information. So the court does not go, generally the court does not go beyond the four corners of the information. Remember, you are seeking a quotient of the information on the ground that the facts charge where? Facts charge in the information do not constitute an offense. Because the accused has the right to be informed. I told you, the right to be informed of the nature and cause of the accusation. Nandun, every indictment must contain or must allege facts constitutive of each and every element of the crime charge. If those facts are not sufficient to constitute the elements of the crime charge, vulnerable to a quashan. Yan yun. So you are attacking the very information itself. You are attacking the very contents of the information itself. The facts charge. So generally, the court does not go beyond the four corners of the information. Okay? Court has no jurisdiction, etc. Okay, now, the criminal action or liability has been extinguished. Please take note yung extinction of criminal liability here as a ground for a motion to quash must be total extinction. Diba, you learn in yung criminal law, if there is partial and total extinction, yung partial extinction, yung commutation, yung good, ano ba yan, yung commutation, conditional pardon, yung mga ganyan. So those are partial extinction of criminal liability. What is a ground for a motion to quash is total extinction of criminal liability. Where there's total extinction, death of the convict. Diba? Death of the convict, absolute pardon, suspension of sentence, service of sentence. Ito yan Itong word ko Total extinction. The word I coined next to the bar. Yes, the convict, not the required to spend the party, absolute pardon, serve for sentence, prescription of crime, amnesty, heirs to the offender, the offender's party, prescription of penalty. And that's all. Okay, if there is total extinction, that should be a ground. That should be the one that is a ground for a motion to quash. That's death of the convict. Did you know? Not death of the private defendant party, because the private defendant party is simply a witness in a criminal case. So it is the death of the convict. I think we mentioned this in Bayotas last night. That's total extinction. Death of the convict, absolute pardon, not conditional pardon. That is partial extinction. Absolute pardon, service of sentence, prescription of crime, amnesty, marriage between the offender and the offended party in certain cases, and prescription of penalty. These are the grounds for total extinction of criminal liability under criminal law, and which can be grounds for a motion to quash. It is not every extinction of criminal liability that can be a ground for a motion to quash. Tandaan niya, total extinction. Wala kang basis. Wala kang crime. Extinguish liability. So, the information is subject to okay. It contains affirmance which, if true, would constitute a legal excuse or justification. Ano to? This would refer to what? Mga justifying circumstances, exempting circumstances, which if true, would justify, would be constitute a legal excuse or justification. Okay, nandito tayo sa last ground for a motion to quash, as stated in your rules on criminal procedure, is DJ, double jeopardy. DJ, double jeopardy. Now, tandaan nyo na, as far as DJ is concerned, the accused has been previously convicted or acquitted of the offense charged, or the case against him dismissed or otherwise terminated without his express consent. If you notice, may nawala dito. The accused has been acquitted or convicted. Di ba before? The accused has been acquitted or convicted or in jeopardy of being convicted. Di ba? Sa tinanggal na yan, simplified na. The accused has been previously acquitted or convicted, or the case against him has been terminated without his express consent. Now, please, so what would be the requisites? Simple lang please, huwag kayo niyong guluhin sa sarili niyo. Requisites for double jeopardy. Kasi kaya double, dalawa. Di ba? Double jeopardy. For, kailangan meron mo ng first jeopardy. What would be the requisite? The first jeopardy must have attached. Number 2, the first jeopardy must have been validly terminated. And number 3, the second jeopardy must be for the same offense. For the same offense or the second offense that necessarily includes or is necessarily included in the first offense. First jeopardy must have attached. First jeopardy must have been validly terminated. And third, the second jeopardy must consist of an offense, the same offense, or an offense which is necessarily included in, or even an attempt to commit the first offense. Okay, now, what is the first jeopardy? What would be the requisites? When do we say that the first jeopardy, kasi double yan when do we say that the first jeopardy has attached? Okay, if there has been a valid complaint or information filed against the accused before a court of competent jurisdiction, valid complaint or information against the accused before a court of competent jurisdiction, the accused has been arraigned. Yung proseso. Valid complaint or information filed before the court of competent jurisdiction, the accused has been arraigned on that charge. He has already been arraigned on that charge. There has been a valid plea during the arraignment, and the accused has been convicted or acquitted, or that case has been terminated without his express consent. Yan ang first jeopardy. Now, in other words, if a valid complaint or information has been filed against the accused before a court of competent jurisdiction to which he has pleaded not guilty, and there was trial on the merits, and the accused, and which resulted in the conviction or acquittal of the accused, or there has been a dismissal without his express consent, second prosecution, second jeopardy, it will already bar his prosecution for the same offense in the second. Pagka pareho yung offense in the second, or it necessarily includes, or is necessarily included in the first offense, na-terminate na, because there will be judgment resulting in conviction or acquittal, then it will already bar his subsequent prosecution for the same offense. Clear ba o mas malabo? So, first jeopardy, mag-attach, yun ang requisites ng first jeopardy. Natapos yung first jeopardy, it will bar his subsequent prosecution for the same offense. Yun na. Natapos through an acquittal or conviction or termination without his express consent. Please take note, the test of a jeopardy is the crime charged, not the crime proved. Meaning that you can't charge in a second. That is the test on whether there will be double jeopardy. Kasi if the same offense is charged subsequently after the first jeopardy has already been terminated, yan, may double jeopardy. So the test of jeopardy, what is jeopardy? Di ba danger, peril? Okay, the test of the jeopardy is the crime charged, not the crime proved. The crime charged, not the crime proved. Okay, now, we're talking about the termination of the first jeopardy, either in conviction or acquittal or the dismissal of the case without the express consent of the accused. Dismissal of the case without the express consent of the accused. Take note that not every dismissal, or termination of the case amounts to an acquittal. Dismissal of the case is basically different from acquittal of the accused. Pag na-dismiss ang case, ma-acquit ka, correct? That's follows it. If the case is dismissed, the accused is acquitted. But these are two different concepts because a dismissal may be on the ground that the court has no jurisdiction over the case. So that is without prejudice or refiling of the information before the court of competent jurisdiction. Correct? Or a dismissal may be due to the coercion of the information because the facts charged do not constitute an offense. Yeah? So it is a dismissal without prejudice. Now, what could an acquittal, when you talk about an acquittal, basically, when you talk about an acquittal, that is after a consideration of the evidence, meaning after a judgment on the merits. There's already a trial on the merits, and there's a consideration of the totality of the evidence, and there is a judgment of acquittal. Yan, usually and generally, that is the concept of an acquittal. However, there are instances when a case is dismissed, and the dismissal is tantamount to an acquittal. Kasi, Lisa, pagka-acquittal, papasok na ang double jeopardy. Paano nyo? Na-acquit siya from this case, because the case has been dismissed on the merits, and therefore acquitted siya, that could amount to double jeopardy, to bar his subsequent prosecution. What I'm drawing out is not every dismissal can bar subsequent prosecution. It must be a dismissal that is an acquittal. Kala nyo? Para pumasok ang double jeopardy, it must be a dismissal that is an acquittal. Or at least it is tantamount to an acquittal. So titignan nyo, if the dismissal is without prejudice, for example, the ground of lack of jurisdiction, it is a dismissal without prejudice. To what? To the refiling of the information before the court of competent jurisdiction. However, there are dismissals that could be tantamount to an acquittal. I made mention of one. Hindi ba violation of accused right to speedy trial? Kanina I told you, if the case is dismissed on the ground of violation of accused right to speedy trial, that dismissal is tantamount to an acquittal. Ergo, pasok, DJ. Pag sinabing tantamount to operates as an acquittal, pasok, DJ. What else? Kung dismissal. For example, yung dismissal of the case as against one who has been discharged to be utilized as a state witness. Yeah? If a person has been discharged, if an accused, several accused charged under one information, one of the accused is discharged to be utilized as a state witness. If he is discharged to be utilized as a state witness, the discharge is tantamount to or operates as an acquittal. Paso, DJ, he can no longer be subsequently prosecuted for the same offense. Yeah? What else? What could be an example likewise of a dismissal of the case that could be tantamount to an acquittal para pumasok ang DJ? Yung if the case is dismissed via the murder to the evidence. You know the murder to the evidence? What is your ground for the murder to the evidence? Similar to SIMPRO. What is the only ground, take note, for the murder to the evidence is insufficiency of evidence. All these grounds for motion to quash are no longer available in the murder to the evidence. The only ground for the murder to the evidence is insufficiency of evidence. You must always bear the burden of proof. Generally, unless the accused interposes an affirmative defense, the burden of proof in a criminal case is always on the prosecution. that they have to prove the guilt of the accused, yet reasonable doubt, because the prosecution has the burden of proving the liability. General yan eh, because there's also the presumption of innocence in favor of the accused. So at the first instance, unless the accused pleads an affirmative defense, ang burden of proof is always in the prosecution to prove that he committed the crime charge. Okay, so pag demand to the evidence, sabi, so the burden of proof, meaning insufficient evidence, a demand to the evidence divides a motion to dismiss. It is in the nature of a motion to dismiss. A motion to dismiss by way of a demand to the evidence. What do you mean by demand to the evidence? This is an objection to what? To the sufficiency of the evidence presented by the prosecution. Therefore, if the motion to dismiss by way of a demand to the evidence is granted, dismissed. Case is dismissed. That dismissal is tantamount to an acquittal. Therefore, pasok, DJ. It will bar his subsequent prosecution for the same offense. Is it clear? Now, if, sabi natin, for purposes of PJ, the dismissal must be, the termination of the case or the dismissal of the case must be without the express consent of the accused. Yeah? Kasi conviction, acquittal, or the case is dismissed without his express consent. Dismissed or terminated without his express consent. We're to the last, no? Yung dismissal. Okay. It must be without his express consent. Now, there are instances, however, where the dismissal is at the instance of the accused. Di ba? The dismissal is at the instance of the accused. Move to dismiss. With his express consent, okay, the prosecution, Your Honor, has failed to present evidence anew. May I move at least for a provisional dismissal of the case? Provisional dismissal of the case. Meaning that it can be revived. You agreed to the provisional character of the dismissal. So it's a provisional character. Kailangan yan, it must be on your motion with your express consent that the case is dismissed. If it is with your express consent that the case is dismissed, you are likewise giving consent to its revival. Yeah? Now, before the revision of the rules, if the case is dismissed provisionally with the express consent of the accused, it can be revived. Very clear naman yan eh. If it is dismissed provisionally without the express consent, with the express consent of the accused, it can be revived. Now, what the lawyers did before the revision of the rules is, after 6 months from the date of the provisional dismissal of the case, they moved for permanent dismissal. 6 months after, kasi hindi nire-revive. So, we need to know prosecution asking for filing a motion, excuse me po. May Enriquez yan. Okay, so, asking for a provisional dismissal of the case. So, a permanent dismissal of the case. Ano sinasabi ng Supreme Court? It's an old case actually, it's a 1978 case. Pag na Supreme Court din, yung Laucheco versus Alejandro. Ano yan, no? Yung sinasabi ko lang yung background. Laucheco versus Alejandro, sabi first, no! Because you know very well, but even if the case is dismissed provisionally, tumatakbon pa rin yung, once the case is terminated, whether, even if it is terminated or dismissed provisionally, meaning subject to revival, tumatakbo na kaagad yung, di ba, prescriptive period of the crime. So, according to the Supreme Court, even if the case is provisionally dismissed, the dismissal cannot be permanent until after the offense is prescribed. Until after the offense is prescribed. So, there's no such, according to what justice, there's no such animal as a motion for permanent dismissal. Because for as long as the crime has not prescribed, you can still move for revival. Ngayon, under the present rule, they made it simpler. Pinasok na nila ay ngayon, time bar rule. This is a bagong concept, di ba? Under the new rules, the time bar rule. A case is dismissed provisionally. Ang titingnan lang ninyo, the penalty for the offense charge. It is on motion, ito, Section 8 of Rule 117, a case shall not be dismissed provisionally except with the express consent of the accused and with notice to the private offended party. Siyempre, to give the private offended party the opportunity to seek a revival of the case. Di ba? A revival of the case. So, if you cause the dismissal of the case provisionally, kailangan it has to be with express consent of the accused, express consent of the accused, and with notice to the private offended party. Okay, ito yung time bar rule. What does it say? Pag sinabi, if he is charged with an offense for which the imposable penalty exceeds 6 years, the dismissal can become permanent after 2 years from date of the issuance of the order of provisional dismissal, provided that within a period of 2 years, walang motion to revive. It has not been revived, no motion to revive has been filed. If, on the other hand, the accused is charged with an offense where the imposable penalty does not exceed 6 years, the dismissal, provisional dismissal, can become permanent after 1 year from the order of the provisional dismissal, from the date of the order of the provisional dismissal, provided that it is not revived, or there is no motion to revive that has been filed within a period of 1 year. Kailangan kasi provisional yan eh. So why is it called time bar? Binibigyan pa rin ang prosecution ng opportunity to revive it. So, if they do not act within the period as now fixed under the rules, if the prosecution is dismissed provisionally, so provisionally is subject to revival, but you cannot have it all according to the Supreme Court. So, if you're given an opportunity to revive, balancing of interest, balancing of factors. The dismissed, so you have to put a time limit to the right of the prosecution or to the privilege of the prosecution to seek a revival of the case. So if the prosecution now, or the state does not move within the period allotted, depending on the imposable penalty, 2 years if the offense is penalized with imprisonment of more than 6 years, 1 year if the offense is penalized with imprisonment of not exceeding 6 years. Okay, so if the state does not move, the dismissal now becomes permanent. Barred na, the dismissal becomes permanent. If the dismissal becomes permanent, pasok, DJ. Yeah? He can no longer be subsequently prosecuted for the same offense. If the dismissal becomes permanent. Pero hindi pa papasok yan if it is provisionally dismissed. Remember, there is a case of People versus Popular Actor. Yan yung time bar rule eh. Because he was, the cases against them, yung Kuratong Balanay, yung Kuratong Balanay case, it was dismissed provisionally. It was dismissed provisionally. After 2 years, nag-refile. He objected. Time barred na kayo because under the present rules. Time barred na kayo. Sabi na Supreme Court, no, you have to balance it. This is precisely to give the state an opportunity to revive. But at the time your case was dismissed, which was in the case of the Kuratong Balanay was dismissed by Justice Agnier when he was still RTC judge. You can see this. In 1998, at the time the cases were refiled, 2000 na, pumasok na ito, December 2000, yung rules. Sabi ng Supreme Court, you do not apply it retroactively. This is precisely to give the state an opportunity. Kasi makukulangan ang period ng state. This is precisely given 2 years within which to revive. Counted from when? Ngayon lang promulgate lang itong time bar rule December of 2000. So you effectively, if we allow your contention na time bar na sila, that would effectively be depriving the state of the opportunity to revive it. Kasi tapos na yung kaso if i-apply mo yung time bar rule. That should not be the case. The ponente there was Justice Callejo. Sabi niya, kailangan dito balancing din. Precisely binibigyan ng state ng opportunity. If the state does not revive it, that's their lookout. Permanent na yung dismissal. Pasok na, DJ. Get it? Oo. Sumugot naman kayo. Okay, now, so, but sorry, if the case has been dismissed, the case has been dismissed, or the case has been convicted or acquitted, pasok na DJ. Take note of the exemptions to the DJ rule. Yung doctrine of supervening facts. Okay, the doctrine of supervening facts. For example, sabi niya, if the accused was charged initially with physical injuries, convicted of physical injuries, but after conviction, the victim dies. After conviction, so yung anong supervening event dyan? The death. Because he has been charged and he has been convicted of physical injuries. Why pa eh? Why not charge siya na conviction of physical injuries? Subsequently, after conviction, the victim dies. What did the Supreme Court say? It does not fall. Charge of homicide, subsequent charge of homicide does not place the accused in double jeopardy. Why? After the first prosecution, a new fact supervenes. First prosecution for physical injuries. A new fact supervenes, which is the death of the same victim of the physical injuries, on which the accused may be held liable, giving rise to a new and distinct offense. Di ba new and distinct offense yan? Homicide? Kasi patay. Physical injuries, bukay. So, a supervening fact, the fact of death, supervenes, giving rise to a new and distinct offense. The accused cannot be said to be placed in jeopardy of if indicted for the new offense. Kasi totally distinct na yun eh. Although it have proceeded from the same act. Okay, now, let me just go to, before we leave double jeopardy, with respect to the appeal. Take note, if the prosecution appeals from a judgment of conviction, because in the appeal, the prosecution seeks a higher penalty. Na-convict ang accused, resulting in conviction. Okay, now, the judgment of conviction has been rendered against the accused. The prosecution is not contented with the penalty imposed in the judgment of conviction. The prosecution appeals from the judgment of conviction, with the intention of seeking a higher penalty for the accused. The prosecution appeals from the judgment of conviction solely for the purpose of seeking an increase in the penalty imposed on the accused. Can the prosecution do that without violating double jeopardy? No. The prosecution that would amount to double jeopardy as against the accused. If the prosecution appeals, remember this now, it's the case of People versus Leon, it's a 2000 case, and People versus De La Cruz 2001. If the prosecution appeals from a judgment of conviction for the purpose of securing an increase in the penalty on the accused, that is to be denied. Why? Because that will put the accused in double jeopardy. What about, sasabihin niyo, what about, there are cases where the penalty on appeal is increased. Di ba yung Laranyaga? Initially, reclusion perpetua, it went all the way up to the Supreme Court, sabi din. So, na-increase. But tingnan ninyo who filed an appeal. Di ba it was the accused? Who filed the appeal? So, if it was the accused who filed the appeal, in the course of the appeal, na-increase yung penalty pa, it even became worse than they expected. So, but take note, it was the accused who filed the appeal. Ergo, if he files an appeal, he takes all the risks. It is at his instance. So, if he files an appeal, he takes the risks. It could go either way. It could result in the reversal and therefore he's acquitted, or it could go for the worse. And there's an increase of the penalty. But it is at his instance. Ang pinag-uusapan lang that would amount to double jeopardy if it is the prosecution itself or the state itself that appeals from the judgment of the court, judgment of conviction rendered by the court, if for the purposes of increasing the penalty. Take note of that. Okay. You want to take a break? Yes. Okay.